Have you ever pondered the legal intricacies of property attachment by the Enforcement Directorate? A recent Supreme Court case has brought this question to the forefront, challenging us to consider the scope and limits of the Prevention of Money Laundering Act, or PMLA, and its impact on other financial laws. The case in question revolves around a dispute between HDFC Bank and the Enforcement Directorate over 3 mortgaged properties. The properties, acquired before the alleged commission of the scheduled offences under the PMLA, were provisionally attached by the Enforcement Directorate due to allegations of money laundering. HDFC Bank, however, raised concerns about its claim over the properties under the Recovery of Debts and Bankruptcy Act. This dispute raises a significant question. Can a property acquired before the occurrence of scheduled offences under the PMLA be considered proceeds of crime and hence liable to be attached by the Enforcement Directorate? It also urges us to consider whether the PMLA overrides the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, known as the Sarfisi Act, and the Recovery of Debts Due to Banks and Financial Institutions Act. The Patna High Court, in its judgment, stated that the properties in question were not obtained using allegedly tainted money, and therefore do not fall within the definition of proceeds of crime under the PMLA. The High Court also differentiated between the Sarfisi Act and the Bankruptcy Act, stating that they operate in distinct fields from the PMLA. The attachment was set aside and the writ petition was allowed. However, this judgment has been appealed in the Supreme Court, which has issued a notice in the case, opening the floor for further examination and debate. To sum up, the question of whether the Enforcement Directorate can attach a property acquired before the alleged commission of a scheduled offense under the PMLA, and whether the PMLA overrides other financial laws, remains open for further legal scrutiny. This case serves as a reminder of the complex interplay of law and finance, and the importance of the ongoing conversation about the scope of financial laws in India.